Hi, Tony Witt here, Missouri appellate attorney and a guy who tries to make the law make sense on YouTube. Today we have the story of the not very perfect murder. Viola Bowman killed her husband of 35 years and got convicted for it. Let's run on down to the beach and find out why. This is a story of a woman who was married for 35 years to the same man. It is what we would normally think of as a fairly stable marriage. They were married for 35 years, and even though they got close to divorce a couple of times, as you'll see in the opinion, they didn't actually pull the trigger on that. In fact, neither of them pulled very many triggers until Viola Bowman pulled one on her husband. But let's get into the opinion and take a look at what a perfect job she did of convicting herself of this murder.
Well, here is the opinion from the Court of Appeals, State of Missouri versus Viola Bowman. Bowman appeals because following a jury trial, she was found guilty of murder in the first degree and armed criminal action. She challenges the rulings on admitting evidence of her demeanor and appearance after the death of her husband, Albert Bowman, the victim. But because Bowman cannot demonstrate any outcome determinative prejudice in the introduction of the complained of evidence, we affirm. At the time of victim's death, victim and Bowman had been married for 35 years. Why in the world you would put up with someone for 35 years and then kill them is beyond me, but let's read on. The victim was the king of the castle, and he believed his wife should be a stay-at-home mom. This created a lot of friction in their relationship, including fighting and bickering over issues such as money.
Okay, that is one of the things that frequently gets people into trouble and gets marriages into trouble is fighting over money. The way to solve that, particularly if both parties work, is to have two income. If you have two incomes, you should have two bank accounts, one under the control of each person who earns that income. And then you sit down at the kitchen table and you decide who pays what. You know, I'll take the electric bill and the water bill and all of the other ancillary bills if you'll take the house payment. Something like that. That's a way you can avoid having those kinds of issues, because what it really comes down to is somebody wants something and they can't afford it and they blame the other party. And it does lead to a lot of trouble in marriages. But let's see what the opinion says here.
Although they appeared to be on the verge of divorce many times over the years, victim believed divorce was not an option. No matter what, you stayed married for your children. On October 30, 2012, about a week before the victim was murdered, Bowman went to Bank Liberty, the bank through which she and her husband had a home mortgage, and spoke to a personal banker, Angela Woody, and asked about their mortgage life insurance, including whether, if something happened to victim, the mortgage would be paid off. For the one and only time during her 25-year banking career, Ms. Woody took notes of the conversation because it seemed extremely odd to her that Bowman asked so many questions about victim and the insurance if he was not sick, but asked nothing about what would happen if something bad happened to her.
Can we all agree that going to ask the lady at the bank what would happen if her husband died was really a pretty dumb thing to do? It's almost like you're painting a big sign that says, hey, I'm fixing to kill my husband.
About a week before the victim was murdered, Bowman went to the salon where she had her hair done, and she told the salon owner she was looking for the barber who worked there, who had a federal firearms license and bought and sold guns. She told him she needed him to unjam her gun. On November 6th, Bowman attempted to contact her neighbor Kenny Harris for help with a weapon that she had jammed, but he was not at home. Mr. Harris had a federal firearms license, was a firearms dealer, and Bowman and victim had been students in Harris's conceal and carry class in March of 2012.
In the days prior to this murder, she is working on getting her gun unjammed. What I find tremendously ironic is she went to several different people to see if they could unjam her gun. And at the end of the day, it was the victim, in this case, her husband, who unjammed the gun for her. Here, I've unjammed the gun for you. Oh, thank you very much. Bang. That's pretty cold right there. I'm just saying that's pretty cold.
On November 7th, the victim arrived at work at the Kansas City Water Department at 5:41 a.m. and left for the day at 4:46 p.m. Bowman spoke with her daughter, Pamela Franklin, from about 7:30 to 7:45. Miss Franklin heard victim in the background. Bowman appeared rushed and kind of out of breath on the phone.
The conversation with the daughter is important for one reason. It establishes that at 7:45 in the evening, her dad was still alive. Bowman had not killed the man yet. And that is an important fact because it helps nail down the timeline.
Victim's pacemaker recorded a sudden bradycardia episode at 8:43 p.m. And for those of you who don't know, bradycardia is a lowering of the heart rate where the heart rate drops precipitously below usually 60 beats per minute.
Okay, this bradycardia is really important for one particular reason, and that is it establishes the time that the actions were taken that ended the man's life. And of course, it also establishes that she was home at the time when this happened. This is very similar to the kennel video in the Murdaugh case. The murderer in that case didn't know that his son had sent that video to a friend. And it wasn't revealed to him until they were already in trial. Well, here, my guess is that Viola Bowman did not understand how pacemakers worked and that they had a memory and that they wrote to memory. And that memory is necessary if you're going to diagnose anything that goes wrong with the pacemaker during the course of its operation. Because she didn't know that, she thought that she was being smart and clever when she shot the man in the chest in order to shut off the pacemaker. All she was really doing was locking the cell door on her jail sentence.
At 9:08 p.m., Bowman telephoned Mr. Harris's girlfriend about exchanging Girl Scout cookies. She then went over to the Harris house about 10 minutes later and mentioned that she was going to Walmart to get ingredients to make a dessert for victim. At approximately 10:15, Bowman posted on Facebook that she had to go to the store because the victim wanted caramel apples. She then purchased gas at the Quick Trip 1026.
So she runs around and posts all this stuff to Facebook. She makes sure she gets seen on the video cameras at the Quick Trip and the video cameras at the Walmart because she is very studiously creating an alibi. And what's funny about this is that it is so apparent that she is creating an alibi that it's going to cause almost any jury to not buy that alibi. It's like the harder you work to set up an alibi, the harder it is to get a jury to believe it. Juries tend to be rational thinkers, and they think, well, if somebody went to the trouble to be seen on camera at all these different places, I'm buying things at Walmart. Make sure you get my good side. Jurors look at that and go, yeah, that's pretty funny.
And at 10:37, a unit from the fire department was dispatched to Bowman and victim's house after a 911 caller reported a heart problem or cardiac arrest. When the unit arrived on the scene, Bowman met him and said somebody broke into the house and had been in her house and tools were moved, and she was showing the fire captain that. At no point did Bowman ask the fire captain about the victim's condition. The fire captain found Bowman's behavior kind of weird because nobody says that, especially when your loved ones died.
Of course, the fire captain tells us that it's weird that she would say these things and do these things because he's been to a lot of traumatic deaths. He's been to a lot of sudden deaths. He's been to people who've lost loved ones before. And generally, the tears are spilling out all over the place, and nobody is interested in receipts or, surveillance cameras or anything like that. They're interested in the fact that their loved one just died. And apparently this woman could not have cared less. All she's doing here is just creating an evidentiary trail that the police are going to be able to follow. She thinks she's being smart. She thinks she's being clever. Aha, I'm putting together all of the things necessary to prove I didn't do this.
The paramedics came in. They found no heart tones, no breathing. As the crew was leaving, Bowman approached one of the paramedics 3 or 4 times, insisting that he look at the Walmart receipt and pointing out that she bought what she bought and the timestamp. She also mentioned that she thought there might be a couple of guns missing from the house and possibly some tools from the garage. She never asked the paramedic about the victim's condition, nor appeared to the paramedic to be upset at victim's death.
Same thing with the medic's receipt. If are busy trying to show the paramedics the receipt, they are going to think that's pretty weird.
So the Kansas City Police Department got involved, and the crime scene technicians found an overturned barbecue grill, a .22 revolver, a black travel bag, and a black Vivitar digital camera. The technicians observed ash from the grill on the camera and bag. They found no signs of forced entry, and there was no damage to any of the doors or locks.
Okay, the lack of forced entry here is a big red flag for the cops because it means that someone close to him killed him. In fact, in almost every instance where you have a murder of someone, the very first people that they look at are family members. Mother, brother, father, son, sister, somebody. In almost every instance where they solve one of these types of murders, if the killer is going to be somebody who knew the victim and the victim trusted them. And that's why there was no forced entry, because there didn't need to be forced entry. The woman came and went as she wished.
They found a .40 caliber casing on the floor outside the closet door, and another casing was found under the bed. On the bed was an open gun box and a magazine of .40 caliber rounds. On the desk was an open ammunition box of .22 caliber rounds, a brown gun holster, and a small rag.
Okay, in my mind, I have a picture of her, studiously writing down, go to store, be seen on surveillance camera, make sure that you get your face pictured on surveillance camera, and then make sure you load the gun, make sure you shoot, the husband, make sure you throw the gun away so it's never found, but leave the .22 out, which isn't the murder weapon. Throw it in the backyard, make it look like somebody was trying to steal it. You can just see her sort of writing down this checklist of ways to avoid getting caught. And then she leaves the ammo boxes on the bed. Let me see if I have this right, Ms. Bowman. You think that somebody broke in, found the gun that was there, and they went and they got ammunition out of a box and loaded it there on the bed, and they left one magazine on the bed. Okay, if you're going to commit a murder, shouldn't you at least police up the area before you call the cops? Or maybe even before you commit the murder? People do really dumb things.
Kansas City Police Department Crime Lab Stain Pattern Analysis Technical Leader processed the scene on November 7th and 8th. Her findings were consistent with victim being shot first in the head and then in the chest, between 3 to 15 minutes apart. She found no physical evidence that CPR was performed on the victim. They found that there were a number of items dropped sequentially in a line outside the house, headed into the wooded area. The items that were dropped were more than one person could carry. In a clearing approximately 108 feet away from the residence, they found a black velveteen pouch on the ground with Bowman's jewelry in it.
I also love the fact that she's planning all this evidence, taking it outside and throwing it outside, and she just happens to make sure that all of her jewelry gets into a velveteen bag so it can be found and returned to her. Wonder how much of that jewelry she's wearing today. Doesn't look like much.
So on November 8th, the Kansas City Police Department detectives interviewed Bowman. They did about a 3-hour interview. She still had an ashy gray substance on her hands and her victim's blood on her clothes. And Taney noticed discrepancies between the 911 call and Bowman's statements during the interview. During the 911 call, Bowman told dispatch, "Our guns are gone." But during the interview, she said she was not sure the guns were in the residence because she was more concentrated on the victim.
I also love the fact that she told the police that she was more concentrated on the victim, when she clearly, by all accounts, couldn't have cared two whits about the victim, given what she said and did.
Also in the 911 call, she mentioned that the back door to the residence was open, but in the interview, she told detectives that she did not realize the back door was open until after paramedics had arrived. And obviously that's a fairly important thing because the time sync doesn't work out. She tells the cops on the 911 call one thing, and then she tells them something else in the interview, and it has to do with an open door, which assertedly the supposed killer might have come through, and none of it makes sense. So the medical examiner found 2 gunshot wounds, one to the head, one to the chest. Dr. Petak determined that the shot to victim's head was not fired at close range, but the shot to victim's chest was fired at close range. He also determined that either injury could have been fatal. And they were both fired from the same firearm, which was a .40 caliber. On November 9, 2012, Bowman called Ms. Woody at Bank Liberty and asked about the mortgage life insurance. She told the banker she'd been questioned by detectives, but she was not worried. She said she knew she was in the clear because she was on surveillance cameras at both her neighbor's house, and that she went there to see if they wanted some dessert also.
Okay, that was a pretty dumb statement. I'm in the clear because I've got this alibi. All you're doing here is drawing a giant red flag, and the arrow was pointing directly at you.
And at the place where she purchased the dessert. She told Miss Woody that when she got home, not only did she find victim dead, but she found some things moved around.
The statement about being off the suspect list is a really dumb thing to say to a police officer because, first of all, you have to assume that you were on the suspect list to begin with.
On November 30, 2012, Bowman agreed to provide her laptop to Detective Emery. As she was leaving police headquarters, she asked Detective Emery, "So am I off the suspect list now?" Detective Emery had never told Bowman she was on a suspect list and in fact did not have a suspect list.
The statement about being off the suspect list is a really dumb thing to say to a police officer because, first of all, you have to assume that you were on the suspect list to begin with. That's usually a pretty good assumption that you're on there if you're a family member. But you wouldn't want to be talking to the police like that because it makes them think, why do you want off the suspect list?
Bowman contacted Detective Emery again in January 2013 and asked him if he had been aware of any rash of elderly people whose homes were being robbed and the victims of those robberies were being killed and no items taken. Detective Emery told Bowman he was unaware of any incidents other than hers. During the week of January 7th, Bowman went to Bank Liberty to make a claim on life insurance. She noticed when Miss Woody, who was there, noticed that Bowman looked nice, she had her hair cut much shorter, her nails were manicured, and she was now carrying a new purse. Bowman contacted Detective Emery again in January 2013 and asked him if he had been aware of any rash of elderly people whose homes were being robbed and the victims of those robberies were being killed and no items taken. Detective Emery told Bowman he was unaware of any incidents other than hers. During the week of January 7th, Bowman went to Bank Liberty to make a claim on life insurance. She noticed when Miss Woody, who was there, noticed that Bowman looked nice, she had her hair cut much shorter, her nails were manicured, and she was now carrying a new purse. In May of 2013, Bowman contacted Detective Emery again and told him she was running out of money and she needed to get off the suspect list so she could get paid victims' insurance policy.
And then, of all of the really, really dumb things this woman has done in the days after the murder, she calls the cops and says, "Hey, I need to get the insurance money. Can you clear me? Can you clear me a little more quickly?" Again, just a perfect example of the things you don't do if you are truly innocent.
Subsequently, the state indicted Bowman for the Class A felony of murder in the first degree, for knowingly causing victim's death by shooting him, and for felony of armed criminal action. So she was successful in getting herself off the suspect list. She was now on the defendant's list. So further complicating the matter for her, while in the Clay County Jail, Bowman confessed to fellow inmate Katie Cheek that she had killed victim by shooting him with a pistol while he was in his recliner, first in the head and then in the heart to stop his pacemaker, so the pacemaker would not keep him alive. Bowman then told Cheek that she left the house, threw one of the handguns into the yard to make it look like a burglary, and went to the gas station and to Walmart to get receipts to show that she was at the stores at the time the victim was shot. Bowman told Cheek that she murdered victim because she was just tired of taking care of him. It was just a burden to her, and she wanted his insurance money.
And then, of course, the other thing that you don't do if you're truly innocent is you don't go in and tell your cellmate all the information about how you did the crime and why you did the crime, and give the appearance that you are just a soulless cretin. And that is pretty much what she did.
Again, further complicating things, Bowman testified at trial. She said she was cleaning her .40 caliber handgun on November 6th because she and the victim were going to attend a conceal and carry class. The gun jammed, and she had the victim unjam the gun for her that evening. Bowman testified that when victim got home from work on November 7th, they worked on the fence in the yard. She claimed the gray stuff on her hands was the metal coloring from the fence that wouldn't wash off with hand soap. And she testified that she later showed the victim a recipe for caramel baked apples, and he talked her into going to Walmart to get the ingredients. Bowman testified that she called 911 and attempted CPR on the victim. Following the jury trial, Bowman was found guilty.
And as long as we are complicating things by confessing to our cellmate, well, why not complicate things further by taking the stand and testifying and making yourself subject to cross-examination? You'll notice there's not much in the opinion about the cross-examination, but I suspect the cross-examination in this case was pretty brutal.
Bowman first filed a motion for judgment of acquittal or in the alternative for a new trial. Both were denied. And then she appealed, claiming that the evidence that was admitted was an unfair character attack on her. Bowman filed a pretrial motion in limine seeking to exclude any reference to, among other things, that after the death of her husband, the defendant had her hair cut off shorter, which she said her husband had not allowed, had her nails done, purchased a new purse, allegedly appeared to be in a carefree mood, seemed happy at the funeral, and appeared not to be in mourning. So, specifically, Bowman challenged the trial court's admission of the testimony of Ronald Anderson, Pamela Franklin, and Angela Woody over her continuing objection. Mr. Anderson attended the funeral and wake and testified the only thing Bowman could talk about was how nice her hair looked and that the victim never wanted her hair cut short. Ms. Woody, the banker, testified that she almost didn't recognize her when she came in because her hair was cut short. She had a nice new purse and her nails had been manicured. Finally, the victim's own daughter, and Bowman's own daughter, testified she found it odd that her mother had cut her hair short before Dad's funeral because Dad liked long hair. The trial court denied Bowman's motion for a judgment of acquittal or in the alternative a new trial and sentenced her to life in prison without the eligibility for probation or parole on the murder conviction and to 10 years imprisonment on the armed criminal action to be served consecutive to the sentence for murder conviction. In other words, Bowman is never going to see the light of day as a free woman. So we go through the standard of review, which just basically means that a decision about evidence is within the discretion of the trial judge.
I've said it time and time again, complaining about evidence that's admitted, whether it's in a civil trial or a criminal trial, is almost always unsuccessful because the standard is an abuse of discretion. And what is an abuse of discretion? It's when the judge does something that no other judge would do. Basically, you have to get 3 judges on the Court of Appeal or 7 judges on the Supreme Court to say, no, we shouldn't have admitted that. That's a pretty steep hurdle because judges are very reticent to criticize other judges.
Evidence must be both logically and legally relevant to be admissible, but Bowman's point on appeal only challenged the legal relevance. Irrespective of that, the court says the dispositive defect in Bowman's appeal is that she cannot demonstrate outcome determinative prejudice from the introduction of the alleged erroneously admitted evidence. That's because she dug her grave with all of her machinations. And the court says, as we discussed today, there simply is no outcome determinative prejudice here. On appeal, she says the court abused its discretion and it served no other purpose than to inflame the passion of the jury and the sheer volume of erroneously admitted evidence. This is a legal error, I think, that sometimes new attorneys make, and probably the attorney representing her on appeal is a new attorney. And he talks about the sheer volume of erroneously admitted evidence. And the court says, well, the first thing we looked at in terms of the sheer volume is the fact that all of these claims are contained in 42 lines of 6 pages of a 672-page transcript. So less than 1% of the totality of the transcript contained this evidence. That's not a sheer volume of transcript.
Okay, I know he talked about the sheer volume here, and I'm sure that was a mistake, but let's give the guy a break. I'm not really criticizing him. What else did he have to argue? His client managed to leave a trail of breadcrumbs, or perhaps blood droplets, that led from the murder scene right up to her front door. And he didn't really have very much that he could argue against. He just didn't. The evidence was there, as the court very clearly finds.
And it certainly doesn't suggest that it was an exceptional or somehow over the top introduction of evidence in terms of the volume. And then in the prosecutor's argument, the focus was on Bowman's deliberation, not on how she looked. The prosecutor actually turned the focus away from Bowman's appearance and demeanor after the crime. He said, "What this is not about is whether her conduct was odd at the funeral. It's not about caramel apples, really, right? It's about deliberation. It's about using the entirety of what we've seen and we've heard to show that there is deliberation here. Let's talk about the crime scene, okay? Because if this case was solely about her acting odd or cutting her hair at the funeral, then we would have been done on Tuesday. All right, we weren't. So the prosecutor here did a really good job of taking the sting out of any of the erroneously admitted evidence, if in fact it was erroneously admitted. More importantly, overwhelming evidence of guilt may lead an appellate court to find that a defendant was not prejudiced by trial court error. So it talks about how you commit the crime of murder, and deliberation can be inferred from evidence of planning. And there was certainly evidence of planning here. Bowman's fellow inmate provided direct evidence of Bowman's guilt. She told this gal, Katie Cheek, that she had killed the victim by shooting him with a pistol while he was in his recliner. She admitted to Cheek that she shot the victim first in the head and then in the heart to stop his pacemaker so the pacemaker would not keep him alive. A permissible inference of guilt may be drawn from acts or conduct of an accused subsequent to an offense if they tend to show a consciousness of guilt by reason of a desire to conceal the offense or role therein. The state also presented circumstantial evidence. She asked Ms. Woody that if something happened to the victim, would the mortgage be paid off? Woody even asked if the victim was sick, and Bowman told him no, he was healthy, which caused Ms. Woody to feel very uneasy about the conversation. And days before the victim's murder, Bowman attempted to contact several people to help her unjam a firearm that she had jammed while cleaning it, a weapon that not so coincidentally functioned with the same bullet caliber ammunition as that used in victim's murder. Further, guilt may be inferred when an accused attempts to deceive the police in making a false exculpatory statement. Bowman attempted to create an alibi. An alibi is a defense that places the defendant at a relevant time in a different place and renders it impossible for the defendant to be the guilty party. She went to Walmart and was seen on surveillance video. She posted on Facebook that she had to go to the store because victim wanted caramel apples. She did all these things to make her alibi easy to find. And she was more concerned with establishing her alibi than she was with taking the firefighters to where her husband had been shot. So clearly the jury did not find Bowman's alibi story credible. Rather, they found it to be a failed alibi cover-up attempt by Bowman, consistent with the jailhouse confession she made to the fellow inmate. And then she gave inconsistent statements to the police. The extensive evidence presented at trial was relevant and probative of Bowman's guilt and, frankly, demonstrated overwhelming evidence of her guilt. There is no reasonable probability that the evidence of Bowman's appearance and demeanor at the funeral affected the outcome of the trial. Therefore, the admission of evidence like that could not have resulted in prejudice to Bowman. So, the trial court's judgment and sentence is affirmed.
This case is a very good example of what happens when you try to plan the perfect crime. Because although there have been perfect crimes committed in the past, people who committed murders and didn't get caught, it is very rare in the context of a murder in today's world that between DNA, forensic evidence, video cameras on pretty much everybody's doorbell, and all of these other things, that you are going to be able to get away with a murder. About the only people who get away with murder are people who have absolutely no connection to the victim. And if you have a connection to the victim, your every move during the 24 hours prior to the murder and your 24 hours after the murder are going to be studied very, very closely. And if the police can link you to the killing, you're going down for it. This is an interesting case, and it's been something that I think people who are seriously interested in committing a crime, which hopefully none of you are, would do well to take note of. You absolutely can't get away with things like this in today's world. Sooner or later, they're going to come for you, and they're going to put the little bracelets on from behind your back, and you're going to spend the rest of your life, however short or long that may be, in a tiny jail cell. Interestingly, one of the things that I found most interesting in this case is how after her husband was dead, she immediately went to the salon and had her hair cut out short so that she would look better, because she hated the fact that her husband would never let her cut her hair. Judging from the pictures that were posted at the Missouri Department of Corrections, it looks like she's back to wearing her hair long. Well, that's what I have for you today. Hopefully you found this interesting, maybe even just a little bit funny. Although murder is rarely a funny thing, the fact that people make so many mistakes trying to avoid getting caught that they wind up getting caught, that sort of is kind of funny. Obviously, I mean no disrespect to Albert Bowman, the victim in this case, or to Miss Franklin, his daughter, who obviously was pretty upset about what happened. So thank you again for watching. Do something kind for somebody today, and we'll catch you on here next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.